morning, sir. Good morning.
बैठिए। ये 10th-12th कहाँ से किया आपने?
सर सेंट एंसम्स मानसर ओवर जयपुर।
वेरी गुड। और उसके बाद आपने?
उसके बाद सर लॉ कॉलेज था, वेस्ट बंगाल नेशनल यूनिवर्सिटी ऑफ ज्यूरिडिकल साइंसेस।
ठीक है, ठीक। होम डिस्ट्रिक्ट आपका जयपुर है?
जी जी।
अच्छा, जयपुर के बारे में 5 sentences में बताइए।
सर जयपुर इज कंसिडर्ड एज पिंक सिटी इन इंडिया. It is the capital of Rajasthan. It is famous for its culture, traditions and various historical monuments. I have been living in Jaipur for a very long time, so I have a good knowledge of the places around Jaipur. And it is also famous for its artifacts and handicrafts and traditions, etc.
Which monuments of the Jaipur are protected by the UNESCO?
Sir, Amer Fort, Jantar Mantar, which has the sun clock, which is largest in the world. That is all I know, sir.
Okay. If any law enforced in India in respect of the protection of the monuments and historical places,
Yes, sir.
what is the name of that law?
Sir, Archaeological Survey of India.
Archaeological sites
Uh,
and historical monuments remains Act 1958.
1950. Okay, sir.
ओके ओके। आज का न्यूज़पेपर पढ़ा आपने?
नहीं सर, आज सुबह का नहीं पढ़ा है।
फिर जिस दिन इंटरव्यू देने जाओगे उस दिन क्या रहेगा?
उस दिन सर अर्ली मॉर्निंग 8 o'clock होता है, तो उस जैसे कल का पढ़ा था, तो आज का
जैसे आज 10 बजे हो रहा है फिर भी आपने नहीं पढ़ा, उस दिन 8 बजे होगा, उस दिन आप पढ़ लोगे?
नहीं सर, मतलब मैं वही बोल रही थी कि शायद उस दिन सुबह सुबह अर्ली मॉर्निंग नहीं होगा, मतलब तो आई शुड रीड। ओके सर।
और मान लो अर्ली मॉर्निंग हो गया तब क्या करोगे?
वही तो आई शुड रीड।
आज
ठीक है सर।
ओके ओके। अभी कल की कोई घटना है वर्ल्ड लेवल की, किसी को गोली मार कर मर्डर कर दिया गया?
Yes,
क्या?
सर जापानीज एक्स प्राइम मिनिस्टर शिंजो अबे
शिंजो अबे।
यस सर।
गुड। अच्छा, जयपुर में आपका मेट्रो सिटी है जयपुर, है ना?
जी।
कौन से ईयर में बना है ये मेट्रो सिटी?
सर आई हैव नो आईडिया अबाउट दिस।
मेट्रो सिस्टम एंड अदर डिस्ट्रिक्ट का जो सिस्टम है, जुडिशियल सिस्टम्स एंड पुलिस एडमिनिस्ट्रेशन, क्या डिफरेंस है? व्हाट आर द डिफरेंस ऑफ द जुडिशियल सिस्टम एंड पुलिस सिस्टम इन मेट्रो एरिया एंड द अदर डिस्ट्रिक्ट लाइक Jaipur and Ajmer, Jaipur and Bhilwara, Jaipur and Nagaur?
Sir, so as far as I know from CRPC, Criminal Procedure Code, metropolitan cities are considered as those which have population of more than 10 lakh.
It's okay.
Yes, sir.
But in addition to that?
Sir, I don't think if you can enlighten me about that.
We can say that in metro area, the appointment of the metropolitan magistrates, but in other districts the judicial magistrate first class and second class appointed.
Okay.
And what is the difference in respect of the police administration, police system? You know about the police commissionerate system?
Yes, sir.
So if there is police commissionerate system in metro Jaipur? Yes.
No. Okay, there is.
Okay.
I'm unaware about the police administration system.
ये जयपुर सिटी में रहते हैं आप, रूरल में?
नहीं सर, मानसरोवर एरिया में।
मानसरोवर रहते हैं। अच्छा, जयपुर के मेट्रो एंड सेशन जज कौन है? पता नहीं आपको? कितने मेट्रो में डिस्ट्रिक्ट एंड सेशन जज बैठते हैं ये पता आपको?
नहीं सर।
मैडम कह रहे हैं कि 2 बैठते हैं, एक मेट्रो फर्स्ट और दूसरे मेट्रो सेकंड।
ओके।
2 प्रॉपर डिस्ट्रिक्ट एंड सेशन जज है।
ओके।
एक में श्री आशुतोष मिश्रा जी है, एक में कोई और है।
ओके।
अच्छा, ठीक है। ये राजस्थान के लॉ मिनिस्टर कौन है? आइडिया नहीं आपको? ओके। राजस्थान के लॉ सेक्रेटरी?
सर ये मैंने नहीं पढ़ा है अभी, आई शुड रीड अबाउट दिस। अच्छा।
ओके। और इंडिया के लॉ मिनिस्टर कौन है?
सर मिस्टर किरण रिजिजू।
किरण रिजिजू, गुड। और अटॉर्नी जनरल ऑफ इंडिया?
सर मिस्टर के वेणुगोपाल।
के वेणुगोपाल। और राजस्थान में एडवोकेट जनरल?
इसका आइडिया नहीं है मेरे को, राजस्थान के भी
पढ़ना है आपको, ठीक है। राजस्थान हाई कोर्ट के चीफ जस्टिस कौन है?
सर मिस्टर ऑनरेबल जस्टिस एस.एस. शिंदे, संभाजी शिवाजी शिंदे।
एस.एस. शिंदे जी, ठीक है। कौन से हाई कोर्ट से ट्रांसफ़र होके आए?
बॉम्बे हाई कोर्ट से।
बॉम्बे हाई कोर्ट से। ये हाई कोर्ट के जजेस के ट्रांसफ़र का प्रोविज़न कॉन्स्टिट्यूशन के किस आर्टिकल में?
आर्टिकल 215 ऑफ द कॉन्स्टिट्यूशन।
215 इज सिंपली हाई कोर्ट टू बी अ कोर्ट ऑफ रिकॉर्ड.
Oh, so yes, Article 217.
17 is concerned to the appointment of the judges in high courts.
I'm sorry, are you asking about the transfer of judges?
Transfer of the judges from one high court to another high court.
I'm sorry, sir, I'm not able to recall at this point.
कौन सा सब्जेक्ट आपका अच्छा तैयार है?
Sir, evidence law.
एविडेंस एक्ट अच्छा है। मैडम पूछें।
Relevant facts or facting issues difference.
Sir, ma'am, facting issue is basically
Any basic difference
Basic.
between the relevant
basic,
facts and facting issue?
Sir, ma'am, facting issue is the core question in law, which is the point in law of the main problem, and relevant fact basically forms a chain which helps in proving that fact and issue. So fact and issue is basically assertion of a right or liability which is denied by one party and asserted by one party. While when relevant facts are proved, they help in proving that fact and issue. So fact and issue is
Evidence में कहाँ दे रखे हैं?
Ma'am, section 3 of Indian Evidence Act defines fact and issue and relevant fact.
और relevant fact कहाँ से कहाँ तक देखते हैं?
Ma'am, section 6 to section 55 of Indian Evidence Act.
5 to
6 to 55, ma'am.
okay. 6 is about
Res geste, but
Is
that
that
is it's an English law provision that talks about the section 6 talks about that if the fact is not a fact and issue itself, but it forms part of the same transaction, so that is how it becomes relevant.
Okay,
Does that apply on FIR?
It does not accurately apply on FIR, but if it happens in the series of transaction, and if it is in proximity to the events, then it applies. Then
Okay.
it can become a part of the same
Yep.
transaction.
Plea of alibi. What do you know about the plea of alibi?
So plea of alibi is covered under section 11 of Indian Evidence Act. Basically, when the accused takes a defense that he was not present at the spot of the crime, then it is considered as plea of alibi. It is considered as a fact which is inconsistent with the fact and issue or the relevant fact, which is that he was the one who committed the crime. So it is proved by defense, and after it is and the burden of proof is very high on the accused, because the primary burden of proof in a case is on prosecution under section 101 of Indian Evidence Act. And only after that is proved, then you move to defense evidence.
What is the difference between may presume and shall presume?
So may presume is a presumption of fact, wherein it is a discretion of the court whether they will presume a fact or not. For instance, in section 113A of Indian Evidence Act, wherein it is abatement of suicide by a woman. So if she dies within 7 years, it is a presumption of court whether the in-laws abated the suicide. However, in section 113B, it is a shall presumption, which is a mandatory presumption that the court has to presume it, but it is a rebuttable presumption. So then the opposite party will have to rebut that presumption. And
Okay.
yes.
What is meaning of dying declaration?
Sorry, can you
Dying declaration. What is dying declaration?
Yes, so dying declaration is basically, it's defined under section 32 subsection 1 of Indian Evidence Act. It is basically when a person who's affected by the injury, he makes a statement either about the cause of his death or about a circumstance which led to the transaction of his death. In India, it is liberally interpreted, and therefore it is relevant in both civil proceedings and criminal proceedings. But the main precondition is that the victim has to die because of the injury cause. If it does not die, then it is not considered as a substantive piece of evidence.
Which type of the evidence is dying declaration? Whether it is corroborative evidence or any other type?
So it is a substantive piece of evidence, and it has a very high evidentiary value. So if it is
The
duly
dying declaration may be a sole basis of conviction.
yes, sir. It is. It can be. If it is
Any
duly
judgments of the Honorable Supreme Court upon this point?
Yes, sir. In the case of Atbir versus State and City of Delhi, it was a 2010 Supreme Court case. In that, the court held that if it is duly proved, then it will be considered as a sole piece of evidence.
Okay. Who may be a competent witness?
So competent witness is anyone who can understand the questions put to him and can give rational answers to them. Section 118 of Indian Evidence Act defines them. They can be interested witness, child witness, a lunatic person also, so it cannot be presumed.
What is the meaning of examination in chief, cross-examination, re-examination?
So section 137 to 139 talks about them. It basically, when in a trial, the accused is the witnesses are put questions to. So examination in chief is when the party who has called the witness, he puts question in forth of the witness so as to establish his testimony. And then in it is based around relevant facts and issue. And in cross-examination, the opposite party tries to discredit the testimony of the witness. In that also revolves around fact and issue and relevant fact, but it is not necessary that it only revolves around examination in chief. And then re-examination is not a mandatory process. That can be done by prosecution only, like the party who has called the witness, and that is a method so as to explain any circumstances or any contradictory fact which might have arisen in cross-examination.
Good. What is leading question and when it may be asked?
So section 141 of Indian Evidence Act defines leading question. Leading questions are the kind of questions which the opposite party asks in a way so as to expect an answer which they were hoping to get. For instance, leading questions can be asked in cross-examination as a general rule, but in
leading question suggests itself answer in that question.
Yes. So for example, if I can give an example, have you stopped hitting your wife? So this question can only be answered in yes or no, and whatever answer you give, it might lead to some incriminating fact. So that is why these questions are only allowed in cross-examination as a general rule. But you can take the permission of the court and can also ask.
When calling party can cross-examine the own witness?
Calling party, also in case of hostile witness, under section 154 of Indian Evidence.
154, very good. And when court can ask the question, under which provision the court can ask the question from the?
So section 165 of Indian Evidence Act.
Okay. When the court question is asked, then the party has right to cross-examine?
No, sir. They do not have the right. They can take the permission of the court.
Okay. What is admissible in evidence in case of the in respect of the contents of electronic record?
So section 65A and B talk about admissibility of electronic evidence. They are admissible only if the computer output of the electronic evidence becomes admissible.
Whether certificate is mandatory?
Yes, sir. Sir, in the recent case, in 2020 recent judgment of Arjun Pandit Rao versus Kailash Rao Gorantyal, Supreme Court has mandated that you need a certificate so as to make the electronic evidence admissible.
Okay, what is the primary evidence?
So primary evidence is the document itself.
Original document?
Yes, sir. Original document
itself or the original document, yes, which produced before the court?
Yes, sir.
Okay.
Section 16.
So what is the basic difference between the patent and latent ambiguity?
So patent ambiguity is apparent on the face of it, and latent ambiguity is hidden. It has to be, you have to look through it to understand it.
Okay. What is the burden of proof?
So burden of proof is when a party asserts a fact, then the burden lies on that person so as to prove that fact. For instance, if the prosecution files a case, then the primary burden will always be on the prosecution under section 101 of Indian Evidence Act. However, if the defense suggests a fact, then the burden will shift to him to prove that individual statement. That is called the shifting burden of proof under section 103 of Indian Evidence Act.
CPC is already prepared by you?
Yes, sir. Yes, sir.
Very nice. What is the meaning of issue?
Sir, issue is a question in law which is asserted by one party and denied by the other.
Only the question of law, not the question of fact.
Yes,
not
it
the
can
point
be it can be question of fact or question of law as per order 14 of
upon which materials the issues are framed by the court?
So it is framed on the basis of the written pleadings and oral pleadings and the documents which are submitted by both parties.
Okay, pleadings, documents,
yes,
and a statement on oath.
Yes, sir.
Okay, okay. Then what is the basic difference between the rejection of plaint and returning of plaint? Only
Sir,
the one basic difference.
Sir, return of plaint, the rejection of plaint is a harsh remedy because it leads to it makes the proceedings go at the initial beginning as if the plaint was never filed or the suit was never initiated. And if you have to reinstate the suit again, then you have to give fresh court fees. But in the other case, return of plaint mostly happens because of lack of jurisdiction. Under Order 7, Rule 10, it is defined. The provision is given, and in that the plaint is just transferred to another court, and no fresh court fees is required.
Okay. If the plaint is presented before the court which have no jurisdiction, what action can be taken by that court?
Sir, they can return the plaint under Order 7, Rule 10, and if the party who has submitted the plaint, if he applies to the court, then the court can itself transfer the plaint to the other court under Order 7, Rule 10A.
Okay. On the date of the hearing of the suit, the plaintiff is appear but defendant is absent. What action can be taken by the court?
So ex parte proceedings can begin under Order 9, Rule 6, 1A.
If there is due service of?
If there is due service of summons and defendant still return.
Okay. What remedies available against the ex parte decree?
Sir, under Order 9, Rule 13, either the ex parte decree can be set aside by giving sufficient reason for non-appearance, or appeal can also be filed under Section 96, subsection 2 of Civil Procedure Code.
Okay. If the any party which are necessary or proper but not join as a party, how to proceed to add the such party, in pleading that party in a suit?
Yes, sir.
Under which provision?
Yes, sir. The plaintiff is considered as the dominus litis of the case, but if it is a proper party or necessary party which is essential for the adjudication of the dispute, then under Order 1, Rule 10, Sub Rule 2, impleadment of parties can be done by the court.
Okay. What is the meaning of representative suit?
So representative suit is when there are multiple parties from one side, and then the court either asks one of the parties so as to have a representative to address the concerns of all the individuals, or the party himself applies to act as representatives. It is defined under Order 1, Rule 8 of Civil Procedure Code.
Okay. If during the pendency of the suit plaintiff dies,
yes, sir.
Then what further proceeding in that suit?
Sir, if it is a suit wherein the right to sue continues, then the opposite party will have to replace the party with the legal representatives.
If plaintiff dies, it is duty of the defendant.
Sorry, sir. So if the plaintiff dies, then the plaintiff will have legal heirs of the plaintiff will have to apply, and if the defendant dies, then also it is the duty of the plaintiff.
Duty of the which to inform the court in respect of the fact of the death of the party.
So legal heirs of the plaintiff.
Only, not the advocate or the pleader
so
of the deceased.
Advocate can also inform if he gets the knowledge.
If the person who interested to file the suit is indigent,
yes, sir.
Then how to institute the suit?
Sir, under Order 33 of the CPC, the person can file an application in front of the court, and on the basis of the conditions, and then the court will assess whether the person is indigent or not. And if the application is approved, then they can file the suit without paying the court fees, but after
with permission of the court.
Yes, with permission of the court, sir.
To sue as an indigent
yes,
person. Okay. And if the plaintiff is minor or unsound mind person, then how to institute the suit?
Sir, in case of plaintiff, a next friend is appointed, and in case of defendant, a guardian is appointed as per Order 32 of CPC. Okay. And only they can.
And what is the temporary injunction?
So temporary injunction is basically filed so as to prevent the ends of justice from being defeated. So if a legal right is being breached, then the party can approach the court so as to not defeat the objective of law.
What point for determination before what point for consideration before the court at the time of the allow or the disallow the application for TI?
Yes, sir. So in the case of Gujarat Bottling Companies versus Coca-Cola, the court laid down 3 tests, which is a prima facie case, balance of convenience, and irreparable injury to the party affected. And on the basis of those tests, the court determines whether temporary injunction is to be granted or not.
Very good. DV Act भी तैयार होगा आपका बहुत अच्छा.
हाँ जी सर, थोड़ा सा वीक है अभी इतने.
What is the object of passing the DV Act?
Sir, it is mostly in line with CEDAW, the international law, and so as to maintain the dignity and the privacy of the women under Article 21 of Indian Constitution.
Okay, good. Who is the chairman of the State Legal Service Authority of Rajasthan?
Sir, Honorable Justice Mr. Ajay Rastogi, sir.
He occupied the seat in
Yes,
Supreme
sir.
Court.
So I'm not sure, but I read somewhere that under the chairmanship of Honorable Justice Ajay Rastogi,
No.
we have won some prizes for the last 3 years. I will read up about it, sir, because I read some, and also because he is from Rajasthan.
Honorable Justice Srivastav.
Okay, sir. Honorable Justice Srivastav. Okay, sir.
Okay. And who is the chairman of the State Women Commission of Rajasthan?
No idea, sir. I need to read about Rajasthan as I'm understanding by having this interview.
Okay. Narrate any two social customs in Rajasthan.
Sir, Nata Pratha, you know what Nata Pratha, wherein the wife, if the husband either dies or if the wife is unhappy in that marriage, then she can get an informal divorce and can marry another person. And this happens mostly in certain communities of Rajasthan, like Gujar and Khati, etc. communities, not in all communities of Rajasthan. And I also read about this compensatory custom called muta in Rajasthan, wherein if the person gets into an accident, then there can be an informal settlement between them. However, this is not legally recognized in law.
Mutana.
Yes, sir. Mutana.
Mutana. Okay. Narrate any two dialects in Rajasthan.
Kai kar riya hai. This is what are you doing? And so I'm from a village, sir. Like my father.
Which dialogue is prevalent in Jaipur? The Marwadi or the any Bagdi?
So I know about Marwadi.
Hadoti.
In my village, it's Marwadi only. It's near Dosa. So I think that is what.
Marwadi is speaking in Marwad region, the Jodhpur, Jaisalmer, Badmer, Jalore, Paloi, Siroi, including the Bikaner, some part of the Nagaur.
Okay. And in this area, sir, Bagudi?
Which?
Bagdi.
Okay.
Bagdi. Okay. अच्छा, आपका प्लान बी क्या है अगर मान लो आपका नहीं होता है जुडिशरी में तो?
सर, टू बी ऑनेस्ट मैंने कभी भी प्लान बी के बारे में नहीं सोचा, बिकॉज मैंने 8th क्लास में डिसाइड किया था ये
बनने का।
जी, तो
अच्छा, क्यों बनाया जाए आपको जज? Why you are wanted to become a judicial officer?
सर, पहले तो मेरे रीजंस बहुत ही इमोशनल हुआ करते थे जब छोटे थे तब की।
नहीं, ये इंटरव्यू बोर्ड का क्वेश्चन है आपसे।
हाँ जी सर, भाई। तो बट अब सर, as a matter of fact, when I started in law school and I did a lot of internships, corporate internships, various internships, I also interned under Calcutta High Court judge, honorable judge, for 3 months. And then I realized that I also have the skills to be a good judge. He was I'm very grateful to him because he gave me the opportunity to help him, assist him in writing judgments. So I used to do research for him. And I was able to write the judgments properly and I'm a very good listener and very observant. And I feel that these are good qualities to be a judge.
Okay. मैडम कह रहे हैं कि इसको आप ऐसा कह सकते हो कि I having the quality of the judge like the I am good listener, having the patience, having the decision making power, and hard working, dedicated, and I is capable to working without fear and favor, and so many quality. Therefore, I is the most suitable candidate for this job.
Okay, in this way I should present
yes.
myself. Okay.
ठीक है, अच्छा है आपका ऑल ओवर। एक